Let us start off tonight with the Supreme Court that performed the final rites on the Building Bridges Initiative-driven clamour for constitutional changes, with President Uhuru Kenyatta's role in the process being cited as the fatal blow that killed the process. 6 out of the country's 7 top judges faulted the president for usurping the role of ordinary citizens by initiating a constitutional change process through the popular initiative and using the state machinery to push the document. And as Francis Gashuri reports, creation, allocation and distribution of 70 new constituencies was a violation of the Constitution and grabbing the functions of an independent body, the Electoral Commission, IEBC. Citizen TV's Francis Gashuri was at the Supreme Court as the judges walked the country through all the 7 issues brought up for its determination.
We propose that
the fate of the stalled BBI constitutional process passed to the hands of 7 Supreme Court judges after humiliating failures in the High Court and the Court of Appeal. And when Chief Justice Martha Koome moved to pronounce the majority decision, the calm tone hardly betrayed the weight and the sound of the final nail on the coffin of BBI.
the Constitution Amendment Bill of 2020 is unconstitutional. Joaquin Dongo and the Naora Supreme Court judges dissenting.
BBI sank for the same reasons it faltered in the superior courts: the legality of President Uhuru Kenyatta's initiation of constitutional amendments through the popular initiative.
The President cannot initiate constitutional amendments or changes through the popular initiative under Article 257 of the Constitution. Joaquin Dongo, Supreme Court judge, dissenting.
That taking everything into consideration, all the stages, all the processes that led to the bill, I find it difficult to distance the president from the involvement and the initiation of the popular initiative.
In the appeal filed at the Supreme Court by Attorney General Paul Kihara Kariuki, the president had distanced himself from initiating the constitutional amendment push, insisting the process belonged to Suna East MP Junet Mohammed and former Dagoretti South lawmaker Dennis Waweru, who were listed as promoters of the Constitution Amendment Bill 2020, but the country's top judges rejected the narrative.
For starters, the President and the National Executive took certain actions which portray its role in the initiation and promotion of the constitutional amendment. The President did not do those things as a private citizen, and this is clearly demonstrated in a number of ways. 1, the President signed off the communique in March 2018, the official title of the President. The communique was published in a paper bearing the coat of arms of the Republic and the seal of the President.
Although the Secretariat does not disclose its origin, its ancestry, its family tree, its gene cannot be concealed. The affidavit says it all. The great-grandfather is the handshake. The grandfather is the task force, its father is the steering committee, and the surname of all of them is Building Bridges Initiative, alias BBI.
But 2 judges, Joaquin Dongo and Isaac Lenaola, differed with their 5 colleagues in the Supreme Court bench on President Kenyatta's role in initiating the constitutional changes.
From the foregoing, there is no doubt that the President is a democratically elected representative of the people who, under Article 1, can exercise delegated sovereign power of the people. Indeed, this is one of the ways in which constituent power is exercised under our Constitution, and therefore I am confounded by the fact that the superior courts address the constitutional power of the people at length, but for whatever reason fail to take into account that the President is a directly elected representative of the people and he can exercise delegated power on their behalf.
If you look at 257 properly, the process begins with the signature collection and creation and the drafting of the bill or suggestion, and that process was only undertaken by Dennis Waweru and Junet Mohammed, and there is no place in which I have found in the record the role of the president.
The BBI bill also collapsed due to the proposal on creation of 70 new constituencies, ostensibly to resolve the representation inequality as outlined in the second schedule of the proposed law.
The second schedule of the Constitution of Kenya Amendment Bill 2020 is unconstitutional for being in breach of Article 10(2) and 87(7)(a) of the Constitution of Kenya 2020 for lack of public participation. Joaquin Dongo, Supreme Court Judge, concurring.
I find no difficulty in finding that that bill is unconstitutional insofar as it directs the IEBC on not only the elimination of the number of constituencies, but also the distribution of the proposed new constituencies.
And for the third time, the BBI process fell short of constitutional glory before the courts, and this time, for the very last time, at least as a legal question. The clamor for the First Amendment to the Constitution enacted 12 years ago has finally collapsed at the highest court in the land. 19 judges, 3 courts and tens of lawyers handling the BBI matter in the last 3 years or so. The 7 Supreme Court judges dealing with finality with questions raised on the constitutional amendment process. Key among them, the role of the president in initiating a popular initiative. Francis Gashuri, Citizen TV, at the Supreme Court buildings, Nairobi.